Hello.
Good morning.
Good morning.
So I was looking this one over. I don't see Miss Farr here this morning. Did we expect her to be out today? Do you know? Okay. So it looks like we have everything in the file, both parents consenting, all paperwork has been served, reports are all filed. So really on this one, what I need are just final orders. Have you talked to Miss Farr about that?
So I wasn't present at court on May 7th. I was told it was just the final paperwork being submitted. And I guess biological mother, my ex-wife, Lindsay, appeared and objected. So I was expecting Miss Farr and Lindsay German to be present in court today.
Well, I don't I don't see either of them, which is odd. Let
Yeah.
me look back on the notes real quick because I looked at this prior to court and it looked like we had everything in order. Let me see here. You're right, I guess Lindsay German appeared, was going to contact Miss Farr.
I spoke with Miss Farr, I believe it was Thursday or Friday, and she said that she was certain Lindsay would appear in court today, but I'm not seeing her either.
I said we were going to do an attorney for her, and I don't see that. Did we not do that? I was looking back at the notes from the 7th. We gave me this a couple of weeks ago, so I don't remember off the top of my head. I know Miss Farr was going to speak with her. There was a request for an attorney. It looks like that was approved, but I don't see an order in the file doing that. So that may have been overlooked. So I guess given that, what we may need to do is set this out one more time and give everybody an I can get an attorney online and determine if needs to go forward or if it'll be agreed.
Okay.
So given that we'll be let me see where we're at here. I'm thinking about maybe going over 3 weeks to the 18th.
That will work.
Okay, and we'll put that on at 10:30. We get 23, 4. That'll also give us time to get an attorney online and so you can chat with her and see if that is something we need to proceed on.
Okay, thank you for your time. I'll see you on June 18th at 10:30.
Yes, and I'll do an order extending the existing order till that time.
Thank you.
This was set over. Do we have anybody here on this one?
Yes, you have Melissa Wenzel and Charles Black.
Yes.
So right now, Your Honor, we are currently asking to extend the existing order. Mother has chosen to block all contact with all of her children, and myself and father have come to an agreement for Bailey Black to remain in my care. But unfortunately, at this time, we are having problems being able to locate mom and for her to agree. She has not had any correspondence with any of her children at this time.
All right. Mr. Black, I see you on there. We've chatted before. Is that your understanding, sir?
Yeah.
And so it's your desire for Bailey to stay with Miss Wenzel pending some other agreement?
Yeah, that's fine. Yeah.
Okay. All right. Well, again, I know if there's no case that's going to be filed in California, I guess we would continue with essentially emergency jurisdiction until either that happens or this gets dismissed.
Yes, myself and Mr. Black have come to an agreement based upon his contact and visitation with Bailey. Previously, one of the reasons why this occurred was based upon the medical attention that Bailey needed, which at this time she is receiving. additional resources for that. Unfortunately, like I said, contact with mom has been limited and unavailable. So we would like to ask you to put this matter over to the beginning of July to give us the opportunity to be able to contact mom. Other than that, myself and father will continue to proceed in the agreement that we have for the best interest of Bailey.
And Mr. Blank, that works for you?
Yes, sir.
Okay, so we'll go to July 2nd then. I'll do another order extending. And we will see where we're at then.
Thank you so much.
Okay.
Yes, I'm sorry, I lost you guys.
Have a great day.
Okay, I did note that the full guardianship was filed, so where does that put us today? I don't see Miss Day.
So while my client is incarcerated, it's my understanding we were concerned about the emergency temporary orders lapsing.
Mm-hmm.
And so you requested that the petitioner, I represent the mother who's incarcerated. We asked that the petitioner prepare a petition for full guardianship. I did, per your instructions, I did that for Ms. Glintz, and it's been filed.
Okay.
That's where we're at. It's a procedural issue at this point, I believe.
Okay. And how long is your client going to be in custody again? Remind me.
We've bounced around on a couple of dates. It's my understanding, and Ms. Glintz can correct me, that she's supposed to be out in August or September. Am I?
She will be out in August 12. So that's less than 3 months.
Okay. And you're expecting this essentially to terminate once she's out of custody? Is that the understanding? Or not?
Yes, I understand.
Okay. Well, I'm wondering then, instead of setting these reviews every so often, Mr. Anagnosta, if I just simply entered a temporary guardianship order, I can put a date towards the end of August on that, since we have a full one pending.
The last order entered, the order extending was the wrong order, so it should have been a different form.
On the one on April 2nd?
Yes.
Okay, yeah, so we need a regular emergency minor guardianship. Okay,
That's just mixed up.
all right. So, so any issue with that?
That makes sense to me, Your Honor, that we set it up for a review and basically the termination of the order in late August. And I guess we'll see where we're at that point.
Okay. How about if we go the 20th of August for a review? And the order I'll do will be a regular temporary, a regular minor, emergency minor guardianship order, not this immediate order. So we don't have to keep coming back. Does that work August 20th for both of you?
That works for me, Your Honor.
Okay. So it'd be the same time, same docket. I will get that done right after court and entered, and then we won't have to be back here till August 20th.
Okay. Thank you so much.
Perfect.
All right.
Have a good
Very
one.
good.
Thank you.
Thank you.
Thank you. Bye-bye.
All right. Good afternoon, Ms. German. It looks
Hi.
like, hi, we, on your case, we're extending this out again. It looks like we were supposed to get you an attorney, and that apparently did not happen.
No, I'm not. You guys cannot drop the ball on me and my daughter. She needs to be back with me. This doesn't seem right. I've been doing everything I'm supposed to be doing with my life. She needs to come back home to me.
All right. Well,
It's only fair. My daughter has a fatal medical condition, Your Honor. And I've had 2 kids die with her condition since I left Washington.
okay. Well, ma'am, this is a case where originally there was a consent filed, and with the last hearing, we were ready to enter orders.
Nobody told me I had court. She tried to tell me I abandoned my daughter on the paperwork. I did not abandon my daughter.
I'm not saying that. what I'm saying is you had consented to a guardianship, which is why we're where we're at today.
I consented to her getting medical treatment for my daughter and ordering medical supplies while she had my daughter while I was moving our stuff. That's what I consented to.
All right. Well, I'm just, hold on a second here.
I'm not on drugs. I doing all my classes. I'm doing meetings. I sent in paperwork objecting to the, what's it called? The guardianship.
Okay, well, here's where my problem is today. We've already set this over because there was nobody here when we called it initially.
I was trying to log in. Simply just trying to log in. Like, how am I not with my daughter because I was trying to log in? I've always done what's best for her.
Okay, well, ma'am, here's what I'm going to do. Let me go through a couple other matters in the docket. I'll come back and we'll talk about your case a little more extensively. Okay?
Thank you. I will be here. I appreciate time.
Hold on one second. I'm sorry.
The petitioner logged off. So she's
Okay. All right. So, well,
Your Honor, listen, my daughter has nothing of hers with her. I have her bath chair, her clothes, her medical supplies. I have her bed. I have all of that stuff. She's going without all of that stuff. I sent 10 outfits with her to go be with Mandy.
okay, ma'am, I understand all that. Where we're at is procedurally, we were going to appoint you an attorney at the last hearing that apparently did not get entered. And so I need to do that.
Then I want to be on the court docket for tomorrow.
Okay, ma'am, if you can't listen to me, I'm not going to talk to you anymore. I need to have you listen for a minute. All right? I understand you're concerned about your daughter. I'm not trying to minimize that. I'm just trying to explain to you where we're at right now. Okay?
Okay.
Okay. So we started the docket at 9:30. You were not here. We called the case at 10:30, excuse me. You were not here. We set the matter over to another date, which would be the 18th. And I needed to get you an attorney appointed. And I was going to do that today. And there would not be any permanent orders entered until we can come back on the 18th or until you and the petitioner come to some agreement otherwise. But we all showed up at 10:30 and you weren't here and I didn't have an attorney appointed, so I set it over. And she's now left, so I can't proceed on the hearing today.
Well, who is she? I'll call her and I'll tell her to return if I could. Like, my daughter, I haven't even heard about my daughter at all since she's been gone. I've heard about her one time. That's it. She blocked all of my family. I had Angelique. I had full sole legal custody of her, Your Honor. I took care of her 98% of the time. I found reasons to do things for her, and Mandy found reasons not to do things for her. Just so you know. So I will be quiet. I'm sorry. I do apologize.
Okay, well, ma'am, this case was filed back in November. Okay. There was a consent.
I understand that. That's when I was moving our belongings.
Okay, this was filed in November. There was a consent filed from you saying that you were agreeable to this process, basically, for a temporary guardianship. And then it's been going now since November. So 6 months. And at this point now, and I understand you're objecting to it and you have a right to do that. My concern is that, I don't know what all has been happening in the meantime.
I didn't know there was like a process. I didn't know it was like a thing. Like, I thought it was just her getting consent to take care of my daughter and order medical supplies and care for her. And while I was gone. And then that's it. I didn't know there was going to be more court dates and it was a part of a process and all that stuff. I didn't even know I had court for it. Didn't even know.
Okay. So Miss Farr, who's the court visitor, it looks like she has just logged in.
Yes,
So this is the German matter,
yes.
and the petitioner was here at 10:30. It looked like I was supposed to get an attorney appointed for Lindsay, who's present today. And that apparently did not get done, so I need to do that. I had indicated we were going to set it over to the 18th, at which point the petitioner logged out. I didn't have you here, Miss Lindsay then, or Miss Lindsay German logged in a few minutes ago. And so that's where we're at right now. And she's obviously contesting it, which she's got a right to do. I need to get her an attorney. So I'm just trying to explain kind of where we're at and what the process is.
So prior, at the last hearing, we were ready to enter final orders.
Right.
And then Miss Lindsay German showed up at the hearing.
I
and
didn't
then-
even know I
and
had.
then contested it, and she's still contesting it. So I think that at this point, we need to probably set it for trial.
Okay.
I had no idea I even had court, you guys. I promise you. I didn't even know I had court. I thought it was just like a permission slip to give her permission to order medical supplies and talk to doctors while she had her in Washington. I didn't know it was part of a process or anything. And she blocked all of my family from even communicating with her. So I haven't heard from my daughter at all since she's had her. I had Angelique. I had
There
full
is
legal
also
custody
a
of her.
protection order in place between the two of them, protecting Amanda.
Okay.
I've taken anger management since anything has happened. And it's been years, basically, which is fine. I don't want to see her anyways. I'm not going to keep Angelique from her like she's doing to me. I'm willing to work with her if she wants to be a part of Angelique's life.
Okay.
But keeping me and all my whole family from her is not right. My daughter has a special connection with me.
Ma'am, let me stop you for just a second. We're not having a hearing today. Okay. You were served a summons in this case back in January.
Your Honor, I honestly don't even know what all this means.
Okay.
I'm so sorry.
I'm just trying to explain to you. Okay. You were served a summons which had a court date in it in January of this year. It's 5 months ago.
Yeah.
Okay. And so now we're here and you're objecting to this, which you've got a right to do. I'm not upset about that. I'm just trying to explain to you kind of the process where we're at.
Yeah.
Your case, nobody responded to that case and objected back then. So we all assumed this is going as agreed. So now we're here and that's apparently not the case. So what I'm going to do today, I'm going to appoint you an attorney. I don't have a name right yet, but I will get that for you. Are you still in Bakersfield?
No, I moved back home. I moved to my hometown.
Near Crescent City, Your Honor.
In Crescent City. Do we have a good address for her and
Yes.
contact information?
Yes, I have address and phone and email I can provide to the clerk.
Okay.
I've been at home the whole time since I just put her with Mandy so she can be safe and have the attention she needed while I was moving my belongings.
Okay. Well, ma'am, this was in November. That's 6 months ago.
I didn't think there was a problem with her being with Mandy. She's her mom too. I don't even know she was taking me to court.
Well, you were
I
served.
looked at it like a permission
Okay,
slip.
ma'am, I need you to listen. Okay. You were served papers back
I need
in
my daughter
January.
back.
Okay,
I want my daughter
ma'am.
back in my care. She's safer with me.
Okay, ma'am, I'm going to appoint you an attorney. I'll set a review on this on the 18th, like I just did earlier, like I
How
indicated.
far away? How many days away is that?
That would be, I believe, several weeks.
Your Honor,
I'm not okay with that, Your Honor.
I'm
I
in
want my
trial
kid
on the
back.
18th.
This is not okay with me. I've had 2 kids with mitochondrial disease die since I left
Okay,
Washington.
ma'am,
You don't understand how it's
ma'am, I need to have you listen for a minute. Okay? Ms. Farr, you were trying to say something?
Sorry, Your Honor. I have construction going on. I'm in trial on the 18th in Clark County. If we could set it for the 11th or the 25th, and I can get a hold of Amanda and let her know.
I can do the 11th. That's 2 weeks from today. I was
Okay.
trying the 18th to get an attorney on board, but we can get that done today.
Okay.
So I'll put it on the 11th if you can let her know that. So ma'am, I'm going to get you an attorney appointed today.
Okay.
So they'll be reaching out to you. I'll let Ms. Barr know who that is as well, then get you two connected up, and we'll come back on the 11th and make a decision about how we're going to proceed on this case.
Like, so that's going to be like the decision day or whatever. Cause I need to at least hear about my kid. I need to be able to visit her or something.
Okay. I'm going to get you an attorney appointed, and we'll address all those issues. Okay. It sounds like there may be a protection order in this case that you're not allowed to contact Amanda.
Nothing's happened in years, Your Honor. So that's okay. All that's happening is okay, but like being away from my kid, not hearing about her is just a little bit too much for me. Like I can't even.
Okay.
Like it's
Okay. I'll get you an attorney
it's
appointed
not
today.
good for my daughter either.
Lindsay, there's a process we have to follow. So you're going
So
to have to
every
be
decision you
patient
guys
and follow
make, I
the
have to wait
process.
to see my kid.
You have to follow the process. There's procedures
Right.
in place.
I'm going to appoint you an attorney today, ma'am. They'll be getting a hold of you, and then we'll come back on the 11th at 10:30. And then Ms.
All
Farr,
right.
you can let the petitioner know that date.
I will. And I'll get in touch
My
with you
phone-
this
my
week,
phone-
Lindsay.
When I went to go log in, my phone had to do an update, was why I was late. So I had to do an update before it let me log in. So that's why I was late. Okay. I wasn't like late for any other reason. That
I
was it.
understand, ma'am. I understand that I'm not doing anything today that I wouldn't have done if you would have been here at 9 or 10:30. I need to get you an attorney.
Is there a way for me to be able to know about my daughter, like her, like how she's doing or something?
I'm going to get
she
you an
blocked all my
attorney.
family.
Okay, ma'am, I cannot give you legal advice. I'm not allowed to under state law. I'm going to get you an attorney so you can get legal advice and have an understanding of how to proceed.
Can you put in the order that I could,
That's going to happen today.
the orders to communicate with Mandy or somebody about my daughter?
Well, I can, if you want to talk to Ms. Farr about that, possibly she can give you some more information, but I'm going to get you an attorney appointed today.
All right.
Okay. And I'll set the hearing. That'll be the 11th at 10:30.
All right. I'll be there.
Okay.
I'll be early, so I'm not late. I'm sorry.
Okay. Give me just a second here.
Mr. Lee had sent an email saying he was not available today.
This one, as I recall, we were ready for final orders, and then the mother, Lindsay German, had indicated she was not in agreement. We appointed Mr. Lee and set it to today. Don't see Lindsay German on my screen.
No, I don't either.
And you had an email that Mr. Lee was not available today?
Yes, he sent an email around me.
I don't recall seeing that. That doesn't mean it's not there, but.
So he sent it on June 6th, and let me see if the court was CC'd on that. I don't think the court was CC'd. He sent it to all the parties.
Okay.
Saying he was out of the office traveling and he would not be able to attend the June 11th hearing and would need to ask for a continuance.
Okay. I know we had difficulty locating an attorney in this matter, and that was kind of done at kind of late. I guess my thought on that would be to maybe set it out a week or two, extend the order until we can at least get an appearance from them and see where they're at on this.
Could we do the 25th, Your Honor? I work for the next week, right? So the 25th would be the next Tuesday that I'm available. That's okay.
We could do the 25th. I will not be handling that docket. I don't know if we even have a docket that day, do we?
I believe so.
Do we? Okay. We could put it on someone else that'd be covering that docket. Alternatively, we could go to the 2nd of June,
July.
Let me look at my calendar real quick. Sorry.
but either one is fine with me.
So I work the 2nd, the next Tuesday after that I'd have off would be the 9th of July.
Okay. Well, why don't we go the 25th? That'll give an opportunity. That's a couple of weeks, and Mr. Lee can appear. We can figure out where we're at as far as what we need to do next, and then we can schedule accordingly at that point if we need to.
Okay, thank you for your time. Thank you, Ms. Farr.
Thank you.
You're welcome, and I will extend this order out till that date.
Okay, thank you.
Just by way of roll call, let's see, I see that Mr. Lee, you're on the line. Can you hear me okay?
Yes, good morning, Your Honor. Counsel for the biological mother, Lindsay German.
Okay, great. Thank you for the help with the pronunciation. It's great.
Well, I hope I'm right, but you know, careful taking your cues from me.
Okay, all right. And then also I see, is it Amanda? Is it German? Is that how you pronounce the last name?
Yeah, it's German.
Okay, great. Thanks, Ms. German. And you're the petitioning party, correct?
Yes.
All right. Other than that, let me just double check. I see that Sherry Farr is here, nominated as the court visitor. I think
Morning.
that's still your status, correct?
Yes, and I'm present. Good morning.
Good morning. All right. So I'm not quite sure as for the specifics for today's hearing. I took some notes. It looks like there's a original parenting plan that's in place. Let's see, make sure I'm on the wrong one. Hold on a second. Let me switch over. Helps get on the right one. All right. So in reviewing the file, I see that there's an immediate emergency minor guardianship that was signed off in late November of 2023, and it was recently extended on June 11th to today's hearing. And we have Mr. Lee is representing Ms. Lindsay German, the biological mother, and it looks like that she's still in California. Is that correct, Mr. Lee? Just trying to get my bearings where we're at.
Very fair, Your Honor. That's my understanding based on my correspondence with my client that she's still in around Crescent City, California.
Okay, great. And then the father, it looks like he consented to the guardianship, and it looks like he may still be hospitalized, so we don't anticipate he'll be here today.
Correct, Your Honor.
And so with the order being extended 2 weeks to today's date, I'm kind of at a loss at what is being reviewed or what is being sought today. Maybe the parties could fill me in.
I understand, Your Honor. I'm going to defer to Ms. Farr first, especially courtesy before I proceed.
Okay, so Your Honor, we were at a point where we were getting ready to enter final orders, and on that date, Ms. Lindsay German, appeared for the first time and has since then requested an attorney. She was objecting, and Mr. Lee was appointed. And since that date, we've just had reviews every 2 weeks. I think it was just to get Mr. Lee on board and in touch with Lindsay. The circumstances haven't changed other than that.
All right, thank you, Ms. Farr. Appreciate that. Mr. Lee, any updates on your end?
Yes, Your Honor, that's entirely correct, and I appreciate the court's courtesy in giving me additional time to speak with my client and advisor accordingly. I do not know actually if my client is here or present today. I see Daniel Jones as a Zoom person. I don't know if that's I don't think that would be the JA. Is that Ms. German?
Yeah, let's double check if let's see, is Ms. Let's see, Lindsay German, if you're on the Zoom call, if you'll please unmute and state your name so we know you're present. Lindsay German. All right, not hearing a response, not hearing or not reading somebody's name captioned in the Zoom call as being responsive. There's nobody here in the courtroom. The courtroom is open, and there's nobody but myself and the courtroom clerk. Pardon me. Okay, the court clerk corrected me that the courtroom is not open. This is a purely Zoom hearing. Thanks. All right. So, any communication from Ms. German to any of the parties from Lindsay German, whether she's anticipated coming today?
I don't know so much that it pertains to that, but she did try to contact me twice yesterday, which I reported to the Longview Police Department because I do have a restraining order in place. But one time I didn't answer, and it was the number that was associated with her on the court paperwork. I was served via email. And then a second time was a blocked call. I thought it was law enforcement calling me back, and I answered that, and it was Lindsay, and then I just hung up. So that's the only contact since the last report that I've made. So she's violated it probably 7 or 8 times now.
So Your Honor, my client reached out to me via email yesterday and indicated that she would be present and object at today's hearing. Just for the record, again, as court-appointed counsel, I communicated with my client. I advised her appropriately of my professional assessment of the situation and her options. Of course, that is attorney-client privilege, but fundamentally, she did oppose based on principle the proceedings today. Again, in the interest of balancing representing my client with the best interests of the child, that basically is going to be the extent of my oral remarks today in representing my client, is again that she opposes in principle the minor guardianship and the petitioner, and would like the child returned to her in California. I, again, as counsel here, I see nothing that would actually have me challenge Ms. Farr or the records findings thus far, or the status quo, because ultimately the standard here is the best interest of the child.
Thank you, Mr. Lee. Ms. Farr, do you have any additional comment?
It appears, Your Honor, that we probably should just get this on the trial setting docket then and get an evidentiary hearing and scheduled.
Any objection to that, Mr. Lee?
No, there isn't any objection. Without wandering too far, I just wonder if a default by the petitioner might be more appropriate. But again, I want to be sensitive to the limited role that I have here, and not just throwing out legal advice depending on who I'm representing, but we can certainly put it on the trial setting docket. I just hope that the petitioner and Ms. Farr might have a conversation as well about expeditiously moving this forward, especially if my client is not going to appear further in the proceedings.
She is not going to appear further?
I'm sorry, Ms. Farr?
Lindsay is not going to appear further? Because she did file a formal objection.
Yeah, I will try to, sorry, Ms. Farr, I got ahead of my skis there. I will try to figure out whether or not my client wants to continue to oppose after today's hearing and the rulings accordingly.
Okay, I understand. Yeah, so I don't think that we can do it, that the petitioner can do a default because there's been a formal objection.
I see.
Thank you. And then, Ms. German, you were saying something?
Oh, I was going to say I'm all for the default because I don't. The trial seems so overwhelming and it takes away from our daughter's care and stuff like that. So if there was any way that default could be a way to go, whether he reaches out to Lindsay, she will retract her denial so that it can just be expedited, because it's really just affecting Angelique's care and her quality of life. Because the more time that I'm having to try to put together a case, given that I don't have legal representation, the more time she's not with me, and her condition is fatal and life limiting. So it's very important that I have those moments.
So Amanda, just responding here, Ms. Farr had a good point as well. Just if procedurally, I would have to double check if we can do a default there, but we can certainly communicate moving forward. But it sounds like today we would move forward with asking it would be within the court's discretion to put us on the trial setting docket so we could have fundamentally some resolution in this matter.
Okay.
All right. Thanks everybody for your input. I appreciate that. It looks like Ms. Lindsay German did file an objection it was dated the 14th of May, but filed on the 28th of May, where she objects to the guardianship. As far as substantive, she provides some rationale and some reasons why she's objecting. I think Ms. Farr's suggestion to set it on the trial setting docket to set, maybe a couple hours, maybe a little bit more, maybe a little bit less as far as the trial setting hearing. I think that's appropriate. And then I would also continue the immediate restraining order that was previously signed back in November of 2023 and just keep that in effect. So if there's no opposition to that, we'll take a look at a trial setting docket. Today we are on the 25th of June, and the trial setting dockets, I believe, are on Wednesdays at 1:30? 9 a.m. 9 a.m.
Mm-hmm.
The 3rd of July. That may or may not be convenient for folks. Double check with the parties to see if at 9 a.m. on July 3rd for a trial setting docket to choose a date in which we can set a date for the trial, make some factual findings, and then make a decision on the guardianship petition, minor guardianship petition.
July 3rd at 9 a.m. works for me.
July 3rd, 9 a.m. Great. Thank you, Mr. Chairman.
Works for me too.
Thank you, Ms.
Same,
Farr.
Your Honor.
Thank you, Mr. Lee. We will set that to July 3rd, 9 a.m. We'll choose a date. Today, I will be entering a continuation of the immediate restraining order that was previously entered on November 23. I'll put it effective through I was going to put it on through July 3rd, but I don't know if that docket's particularly the right one to be doing that. So, and I don't know when the next hearing is going to be set. That's becomes a little bit of an issue. So one approach could be is that I could set it through the end of July, and if that's insufficient, then we would be here on July 30th to renew that and make it correspond with the trial date. So that's kind of my thinking, and I'm open to suggestions otherwise. So I'd be setting two dates today, the July 3rd trial setting docket at 9 a.m. and then July 30th on this docket at 10:30 a.m. For the review of the restraining order and to help it be in line with any trial dates that are set.
Could we do July 23rd by chance? I happen to work the 30th. I work a week on and a week off. The 23rd would be better for me.
I'm fine with that.
Okay, thank you.
Yeah, I would make a suggestion, and that is that right now we just have the immediate emergency order in place. If we could enter the actual emergency order that would extend for the full 60 days, that should then cover without any further extensions up until an evidentiary hearing is.
Okay. Thank you. Mr. Lee?
No objection, Your Honor.
Okay, so I'll do that. I'll enter that emergency order will be in effect for 60 days. We will not come back here on the 23rd of July at 10:30 a.m. We will come back on July 3rd at 9 a.m. in which a trial date will be set, and then everybody will come on that trial date.
And
Thank you.
then, Your Honor, we
Appreciate
should.
your guys' time.
Sorry, Ms. Sherman, can you repeat that?
Oh, I said thank you. I appreciate your guys' time.
So, Your Honor, I would suggest that we still do at least schedule a follow-up review at close to the 60 days.
Thank you. Today being the 25th, that would be roughly, let's set it for August 20th at 10:30, if that works for everybody's schedule.
Yes.
Yes, that works for me.
Okay. Mr. Lee?
That should be fine, Your Honor.
Okay, great. August 20th at 10:30 will be a review
where are we at on this one? We were trying to get Mr. Davis served.
He has been served, and I have completed my report, served both parties. We were going to prepare the final documents, and I contacted Mr. Goodday. Is he on?
I believe I saw
Yes.
him on here. Yes, he's here.
I don't think Mr. Gooday's had much contact with his client. So the question is, because she's been appointed an attorney, she appeared at least at one hearing, but she hasn't filed a formal objection. Can we go forward or not?
Mr. Giddy, what's your client's position on this case?
I knew she was against it, Your Honor, but I haven't had contact with her in a few months, so that's the most recent information I had.
So you're obviously not in a position to stipulate to an order if she was indicating she doesn't want that. Is that right?
Correct, Your Honor.
So we probably need to set a hearing on this one. And this one, this is an emergency one as well. We don't have a permanent filed.
We do. Everything's
Do
been
we?
filed in this one.
Oh, I see. There it is. Hasn't been switched up there. The title's still showing an emergency on this one. It looks like we had one filed in November.
Yeah, everything is completed. Mr. Heber's done everything that he's supposed to do.
Okay.
There's been no contact from the parents.
All right. So what my thought on this one would be like another one we were talking about earlier would be to go ahead and enter essentially the emergency guardianship order, not the immediate order. Set it for a hearing on the other one at some point out in the future. We can set it on for a trial assignment docket to do that. So we can work around Mr. Goodday's schedule, and then we can have a hearing. And if she decides to attend, then that's fine. If not, we'll proceed.
Thank you, Your Honor.
Okay, so what I think I will do, I'm going to go ahead and just enter the regular temporary guardianship order, not this immediate that we
Okay.
do. Yeah, one of those. We have one of those here. This should be Mr. Haro being appointed. Is that not correct?
Yes, Mr. Hero.
Okay, so this is, let me fix this order. So because we don't have a hearing scheduled, I'll need to set a review out about 60 days, but I can also put this on for trial assignment so we can get that done. So I'm going to go July 23rd. And is everybody available for a trial assignment docket? I could probably do, could we put it on for this Wednesday?
This Wednesday.
Okay. Do you want to try and do it this Wednesday? It's at 9 o'clock for a trial assignment?
You mean tomorrow?
I'm sorry?
You mean tomorrow?
Oh, tomorrow. Yeah.
Oh.
Sorry.
That
That's
works
Wednesday.
for me. That works for Mr. Goodday.
Mr. Goodday?
Yeah, that'd just be a Zoom hearing.
It'd be a Zoom hearing. Yeah, it's just for trial setting. It's at 9 o'clock on the 29th tomorrow.
Yeah, no objection.
Okay, so we'll put it on for assignment the 29th at 9 o'clock. I'll set a review date, like I just indicated, on the 23rd of July. And if we have the trial prior to that time, then that'll resolve it. If we don't have it prior to that time, I'll extend this order to the trial date. Okay?
That
Thank you,
works.
Judge.
Thank you, Your Honor.
You're welcome. This is also Ms. Farr. This was the one where we had the other custody case, is that?
This is the one where we all are somewhat confused about the process of converting the NPC to the guardianship.
So I think on this one, have we had service done on this one or not?
No, not yet. We did in the emergency portion for the mother, but we haven't been able to re-serve her and also serve the father.
Okay.
I also have a question. Can I serve them even though we're having this confusion with the conversion? Can I do that currently? I wasn't sure if I could work on that right now until we got this taken care of.
I'm not sure I understood the question.
Can we try to serve them right now with the confusion going on with the conversion? Can I still, with what we have filed, can I do service?
Yes, I mean, you can still serve them.
Okay.
And I think when I look back through, I didn't see any basis to do a conversion. I don't know the legal basis to do that. Even if we were to do that, you'd still require, I would think, that there'd still need to be service on the parents of it.
There still has to be service. The basis was because someone else has custody under the NPC. So to be, the confusion is the process of converting the NPC to the guardianship. That's what we were talking about. And she did file just the petition, but there's already the NPC in place. The custodian under the NPC is consenting to the guardianship.
Right, but I think we still probably have to serve the parents.
Yes. I think we were kind of holding off so that we could serve them all the documents at once, not knowing what documents had to actually be filed.
Well, I think the summons and petition, which have been filed, they were filed April 22nd. Probably those two. This one's really kind of a sticky one because of we're modifying the custodian and modifying it from the custody to the
Right.
third party. And have we heard anything back from either parent?
I believe Angie's had some contact with her daughter, but she didn't have paperwork to serve her at the time. So I think there is possibility of service, but it's very sporadic contact. I know that their parenting has been limited in the past. Do we still need to serve them?
So Ms. Farr, on this one, I guess I'm wondering, part of your role is to determine whether a parent can be served.
Right. But part of the reason that we were holding off was because if the motion and order to convert was going to be completed, which we still are confused about, then we were going to serve her with that along with the summons and petition instead of trying to track her down twice. So we've kind of been in this limbo for at least 2 hearings trying to figure out the process.
Just 1 second here. The last time I looked at this, which would have been the last time we were here, and I know we've got a mandatory form here, but I didn't see.
So when the petitioners tried to file the motion to convert into the NPC case, the clerk said no if that case was closed and she couldn't file it into the NPC, but there's no other way to convert it unless that is filed.
I'm sorry.
The law changed, so we cannot file anything in the non-parent custody cases.
Okay. What my clerk's indicating is that they're unable to file anything into those cases based on a change in the law, which I'm not seeing here, but I'm also not seeing under the petition to terminate or change that was filed here, which is the Guardian Form 502, which is a standard form. It references 4 different statutory provisions, none of which that I can see provide for
None of them have anything to do with the NPC.
right. They all have to do with guardianship. So I have no idea why that order or that petition even exists, because there's no legal basis that I can see for it. So I think really just the standard summons and petition, which are already filed, which was April 22nd. I think as long as those two, without the temporary, probably doesn't need to be filed. We could, at this juncture, we have consent from the current custodian, could probably just enter the full temporary order, serve that along with the summons and petition, and then see if they
reference
respond.
in that order that it's terminating the NPC.
We could do that, I think. That would make sense.
Okay.
Do we have an order on this one? Let me see if we do. Problem is we can't file this in that other case, can we? It doesn't make any sense. So what I've got is I've got 2 orders that looks like the Foxes have provided. One is terminating the prior non-parental custody order. One is the emergency minor guardianship, which I can grant that one for 60 days. I'm going to change this 60-day date to be 60 days from today, which will put us out. What was that last one I just did an order for? Was July 2nd for a review date. And then I'll grant the order as previously provided. I think I'm inclined to hold off on the termination order, because if for some reason this whole thing were to kind of come to a halt, we would still have that third-party custody order in place until we have this one turned over.
Okay.
I think that makes sense. So I'm going to hold off on the termination order at this point. So what I guess we'll need to do then is to get them served. We'll set a review date on the 2nd of July. They should be served this order, the summons and petition, on the regular guardianship, and then we can go from there.
Okay.
All right. Thank you, Your Honor.
Thank you so much.
Good morning.
You're welcome.
I
So
don't know.
I'm sorry?
Oh, I don't know if the petitioner is here.
I'm here. I'm here.
And could you identify yourself on the phone?
My name is Douglas Eru. I'm Elliot's grandfather.
Okay. And you're,
Who?
I'm Doug Eru. Is this for a case for Elliot Davis?
No. Hezekiah
I'm
Mines?
sorry.
I think we already did that case, didn't we?
I had a hard time getting online for this.
All right. And I believe on that one, we've already handled that case, sir. You may want to reach out to Ms. Farr. She can update you.
Thank you very much, Your Honor.
Okay. This one, this is the one where we have the non-paternity matter. And let me just see here. My computer's acting up here.
And last time we met, the grandmother was going to email me a copy of the birth certificate, which she was anticipating receiving the following day. And I have yet to receive the birth certificate.
I emailed it to you.
I have reached out to you again. I have not received it.
Sorry, I'll double check my emails right now because I know I emailed it to you. I just see your one that says you have not received it.
Ms. Turnbull, maybe you could send her an email and then just reply to that with a copy to make sure we got the email address correct.
That's what she had done, and I did that. Let me see. Maybe it didn't go through. I have it right here. I can resend it right now.
And do we have service on this one?
Well, I think we were determining we didn't need to provide service to father because he's not on the birth certificate. That's why we're waiting for the birth certificate, and mother is consenting.
Okay. So it seems on this one, I think, has he been actively involved with the child?
No, and currently there's no contact.
Okay. I think based on that, he would not fall into one of the provisions of someone who's been acting as a parent or has a relationship with a child. As not established, he's not legally the father, so I don't think he falls under the statute in that way. On a third-party custody, we wouldn't be serving him. So in this one, I would think we don't need to. So as long as the birth certificate indicates he's not on the birth certificate, I think we can probably proceed with essentially agreed orders if the mother is consenting.
Can I interrupt real quick? Ms. Turnbull, can you give me your email again right now?
amy@gmail.com.
And then you just need that in order to get your report. Is that right?
That's correct.
Okay. Then I assume once we've got your report, we can probably go ahead and do up a regular because we've got this. We do have a regular in this one. How much time do you think you'll need for that?
If you could give me it.
I apologize. The email was TIRNBULL in my email. So I resent it right now.
At least
a temporary order on this one.
This one's on the immediate, but we don't have a temporary.
Okay. Okay.
Could we do 3 weeks, Your Honor? I have some.
Yeah, this one I think what I'll do in this one, 3 weeks is not a problem. That would be I believe it was the 18th. I'll just do a temporary on this one, another extension.
Very good.
No changes, and then we'll get your report, and if we can get proposed final papers, we'll get that entered.
Okay. Thank you, Your Honor.
You're welcome.
Sorry that I'm technically difficult here, but thank you.
That's okay. No problem. Okay. And I see Ms. Delaney, I see Ms. Farr. Okay.
So, Your Honor, on this one, we're ready to enter findings. I was supposed to have them work with the parties to get them ready for entry for today, but I was out sick last week and didn't get that accomplished.
Okay. So on this one, and we're going to enter the orders in the regular case, correct? 8408. How much you think you would have those orders ready in a couple of weeks?
Yes.
Okay. So if I put this also over to the 18th, the other orders could probably be sent, as long as everybody's approved them, sent in, we could get those entered and even strike that hearing if we've got orders entered.
To the 11th.
We could do the 11th as well,
Yeah.
yeah. Okay, so the 11th of June. I'll just do another temporary on that, and that's on the, don't we have a temporary on the emergency? So I'll extend the 457 out another 2 weeks, and then we can enter the orders on the other case.
Okay. Thank you.
All right.
Sorry for the delay, Ms. Parks, but we'll get
It's
this
okay.
done.
I understand.
All right.
All right.
So
Thank you.
I will get those ordered, entered offline then, and then we'll see you back in 2 weeks on the 11th.
Okay. Thank you.
All right.
Yes, Your Honor.
So we can have both. I think that was on for an interim report. I didn't see anything when I looked earlier.
Yeah, I'd submitted an interim report earlier. And what I was attempting to do, what I was attempting to do for this hearing was to speak to both Mr. Diaz and Ms. Hawkins about voluntarily starting reconciliation counseling so that I could potentially have a track record going into my final report in July. And Ms. Hawkins flat out refused to do that and indicated that she would be needing a court order in order to participate. And so Mr. Diaz had made contact with Charlotte Rosen's office to try to initiate the reconciliation counseling. He has not heard back yet. So in order to, since the assault was taken off the table at the last hearing, now we are in a more traditional mode of trying to establish a parent-child relationship for Mr. Diaz and his children. And so because of the length of time that they have been out of his care, plus the kids are at the point where they don't want to have a relationship with him, reconciliation counseling is definitely needed. However, if Ms. Hawkins is not going to cooperate voluntarily, I would ask the court to order it so that by the time I get to July, I'll have some kind of a track record so I can understand whether we can put a relationship back together for the kids and their father or not.
Your Honor, Amy Powers here for Casey Hawkins. My understanding was that part of what the GAL was investigating was whether the children should even start reunification counseling. So my client's understanding was that that hadn't been ordered yet, and it's been more than 10 years since the kids have had contact with Dad. So we were hoping the GAL would weigh in on whether it should start or not, which is why she had not agreed to start it yet. We thought we were still waiting to hear whether that was going to be recommended.
All right. I'm looking at the appointment order on this case. And the issues to be dealt with were a number of them listed, but one of which was whether the kids should be brought back to Washington, what custody and visitation should be ordered, any other issues that could affect the safety of the children, a number of other things. So this was originally, I believe, on today. Just looking here. But before I can make any words, I think I need some sort of motion in order for me to order anything other than where we're at this point.
If I may, Your Honor, I do believe that
Mr. Diaz, I assume you still have your attorney?
The court has appointed a new attorney for Mr. Diaz.
All right. Is Miss Williams present?
Yeah, this is my first knowledge about this.
Okay. I think we need to get Miss Williams was appointed, it looks like May 3rd.
If the court wants to come back to this matter, I can contact Ms. Williams' office and see if she can log in.
That would be helpful, I think. So let's come back to this in a few minutes when we get Mr. Diaz's attorney present.
That's right.
So I assume Ms. Bliss is not getting involved in this case?
That's correct. And we filed a supplemental declaration late last week. I believe it was on Thursday, kind of giving you the up to moment status. We were in court on May 14th. It was understood, and Ms. Bliss did appear on Mr. Thompson's behalf, indicating that she would be putting in a notice of appearance. Appears to us, and again, we didn't have the information since that time that for whatever reason fell through. I see Mr. Thompson is appearing on his own behalf on the Zoom roster today. We did not get a formal notice of appearance from anyone. We also did not get any responsive pleadings from Mr. Thompson or anyone on his behalf. So largely today you have the same information that you did back on the 14th.
All right, Mr. Thompson, I see you present here. I do see a response that was filed May 20th. I don't have anything else in the file.
Yeah, I think that's all I filed.
So, Mr. Thompson, what was your plan here today, sir?
I guess just to appear and make sure that I'm not being held in contempt or anything like that. As far as, I guess I'm not sure. I don't have Ms. Bliss as a representative anymore, so I'm not sure what I'm supposed to. I guess I need to. I haven't had any contact with my wife at all, so she just has talked to the attorney, and I haven't been able to talk to the attorney. So I guess I'm needing to talk to the attorney about a resolution.
Did you get a copy of the motion for temporary orders?
I did late in April.
Okay, so that's essentially what we're on today for, is to address those requests. And I don't have any response from you. Ms. Bliss, I understood, was going to be filing something.
And you didn't get the response that I sent in?
I have a response to the petition, but not to the temporary.
Oh, not to the temporary. Oh, okay. Because I paid the temporary order.
So I think there's some confusion on that, Judge. We're here on the 14th of May, at which time you did order that you paid $2,000 to my client, had requested in her motion as a bridge to get to this day at his request for the continuance. He did pay that. My client does acknowledge receipt of that $2,000, although it came a day or two after the court had ordered. Nonetheless, she did receive that. Court had given the 2-week continuance to today's date with the understanding that something would be filed in regards to temporary orders. This is the case that you commented on 2 weeks ago, that you had concerns specifically about the month-to-month budget, as well as the credit cards that have been amassed in a short period of time. That you needed some clarification on that, so everybody get their materials in timely or as soon as possible. And again, we didn't get into that. So when I say we're in largely the same position back in the 14th as we are today, I think that's where that comes from. Also reserved on the attorney's fees and costs, pending information from Mr. Thompson, which, as you're aware, never came. Can't say that I don't believe that we were ever served or received a copy of whatever response to the petition that Mr. Thompson submitted, and I'll have my staff pull that up. I'm assuming it was not a declaration or anything that pertains to what we're doing today.
It's a general response to the petition, just a standard response form.
That's what I figured. Well, we're ready to proceed today if you are, Judge.
Well, I reviewed the motion, and essentially the motion asked for some temporary relief, and I haven't got a response to that, nor do I have any. It looks like there was some sort of agreement that encapsulates at least some of this.
Right.
So, Mr. Thompson, I guess, what is your plan here? Are you planning on getting an attorney? Or are you planning on representing yourself, or what?
I guess I can't afford an attorney right now, so I'm representing myself.
Okay. Well, you were served, it looks like you were served this motion back in April.
Yeah.
About a month ago.
Yeah, the end of April.
And so on a short-term basis, at least at this juncture, I'd be inclined to just to grant a temporary motion. I don't have a response to that.
I didn't realize I had to respond to that one, so I apologize.
Well, I mean, it is what I mean, it requires you to do certain things. So, I mean, go ahead.
Sorry, I thought I was responding to the petition overall, so.
Well, you've responded to the petition, so a final order would not be entered today, obviously. We would be having essentially some sort of a trial down the line if that's not an agreement between you and your spouse. In the meantime, for what governs between now and that time, not having any other information, I'd be inclined to just simply enter an order along the lines of being requested.
You want me to present that order ex parte, Judge, or you want to set a separate presentation hearing for that?
You can just send it for ex parte. It's just, as long as it's in line with the temporary orders, there should be a note in there that he would have credit for the $2,000 towards, I guess, the spousal support, which was indicated on there for this month. And then we can deal with everything else.
Very well. And my big concern on this is why I was hoping Mr. Thompson retain some kind of legal counsel, is what can only be considered the bad, excuse me, the bad debt of these credit card expenses. These parties, although combined, make a pretty significant sum of money. It pales in comparison to what they're going to owe on credit cards. My client did submit for you in her initial declaration, the statement and assumption that she was going to speak with a bankruptcy attorney to see if the parties could qualify for a Chapter 7 or 13. She's done that and has indicated the consultation resulted in a discussion about Chapter 7 being kind of the preferred method for that. If we could enter the temporary order and then hopefully have these parties agree to foster a relationship with this bankruptcy attorney or another one that they both felt comfortable with, the exercise of joint bango at this point would probably be behoove both of them and be in both of their interests. So again, I guess that's something that Mr. Thompson and I are going to need to discuss. I don't know that we have the jurisdiction in this court to order that they participate jointly in a bankruptcy. Your Honor certainly has way more experience than that than I do. But nonetheless, that's an issue that we're going to need to resolve very quickly. It goes too deep in the process.
Yeah, I don't believe I have any ability to order the parties to do that. That's certainly something they probably should look into. There may be some challenges with he's not residing here, so he'd be in a different federal court. So I'm not sure if they can file jointly. I don't know that off the top of my head, but that may cause some challenges there. What I'm going to suggest, sir, is you probably should be in touch with an attorney and get some legal counsel. Alternatively, you could talk with Mr. Zandy. He can't represent you or give you legal advice, but he could certainly be willing to talk to you, I'm sure, about how to proceed forward on this thing.
Okay.
Again, I don't know everything about your situation, but it sounds like you got a lot of debt that has at least the potential of being discharged. There very well may be, and again, there was some reference that there had been a bankruptcy filed at some point in the past, which would impact the ability to do that. So,
right.
So you probably, I would suggest you put your heads together with Mr. Zandy and then talk about possible alternatives to address some of these issues, because you guys have a lot of debt from what I can see.
Yeah.
And you say ex parte presentation, Judge, you want to note that separately?
I didn't quite catch that, counsel.
Yeah, and I apologize to you. You want an ex parte presentation of this order, or do you want me to set it now for a presentation in a week or two?
I think as long as it just mirrors the temporary motion, that's fine for ex parte.
Sure. I'll have that over shortly.
Okay, so I'm not going to set any additional hearings today. So Mr. Thompson, again, I would ask you to reach out to Mr. Zandy and talk about how you want to proceed forward. And again, you probably do need to get yourself some legal advice in one fashion or another.
Okay. All right,
Okay.
thank you.
Thank you.
Do we have her?
Yeah, right here.
All right, and you are?
I'm Deja, the mother.
Okay. So are you agreeable to having an order finding paternity in this case?
Yeah, we went through and did the DNA testing.
I'm sorry, I couldn't quite hear that.
Yeah, we went through and did the DNA testing. It came back that he is the father.
Okay, and you're in agreement with that?
Yes, I have no problem with him being put on the birth certificate.
Okay.
but I do disagree with the name change.
Okay, so Ms. Bliss, I was going to set this over because we haven't had the proper timeline for our summary judgment as of today. But if the parties are stipulating to a finding of paternity, that's fine.
And that was my understanding, Judge. I did receive a response from Ms. Scherer agreeing to paternity, but contesting the name change. I'll defer to the court as to how you want to proceed with the remaining contested issues. If you want to address those today, I'm prepared to move forward with that. Or if you wanted to set that matter over, I'm fine with that as well.
Let me see here just a second. All I had on for today was a motion for summary judgment.
Correct. And within our motion for summary judgment, we did make the request to change the child's name on the birth certificate, to which Mrs. has now contested.
Well, the only thing I can grant under summary judgment would be the paternity.
Okay. With that, I can modify the order to establish the paternity, and then once it gets converted into the parenting plan action, I can readdress the name change. So I'll just put reserved as to the name change, I think, at this point.
Yes.
Okay. One issue I did have is we don't have the current middle name for the child nor the birth date of the child. So I was going to request that of Ms. Scherer this afternoon so that I can put that into the final orders.
Sorry, I figured Justin had that information for you.
That's okay. If you could just provide that to me, that would be great.
Do you want it right now, or do you want me to get a contact with you later?
If you could just give it to me now, that way we can just make sure that it's all established, and that way I can get those orders drafted.
Yeah, her birthday.
With that, I will go ahead and can we set up presentation hearing just to make sure that these orders get entered, and I'll make those revisions and put reserved as to the name change.
Sure. You can either do it Friday morning or do it on this docket in a couple of weeks, whichever you prefer.
Let's do this docket maybe 2 weeks out.
Does the 11th work for both of you?
That'll work for me.
All right. So, ma'am, Ms. Bliss will prepare up an order from today, send that to you for your approval, and then I'll be back on the 11th. If everybody agrees to it, I'll just sign it. If there's a disagreement to the language of the order, then we can have a discussion about that on the 11th.
Okay.
Okay.
Thank you, Judge.
Thank you.
Right. You're welcome. Well, it looks like we have everybody here on that. I see Ms. Powers has just gotten into this case, I believe.
Yeah, I've substituted in for Mr. Zandy, and I'm here with Mr. Walker. Mr. Walker is present in my office.
Okay, so we were on, I believe, a week or two ago, and that's the issue when Mr. Zandy came up, and there was a couple of motions pending, one for contempt on child support. One was a motion to strike the settlement conference, which was done, and then the third motion was for an appointment of a guardian ad litem. So the first and the last are still before the court.
Would the court want to handle those separately or jump into both together?
Well, I don't have let me see here. I do have a response from Mr. Walker that was filed the 8th of May on the contempt issue. I don't know what everybody's position is on the guardian ad litem. It seemed to me that was probably appropriate given the issues that were in dispute, but that may be, I don't know if the parties are feeling different about that.
Mr. Walker brought the motion for guardian ad litem and is still requesting one. Given his financial situation, we'd ask that the court make his portion county paid.
Let me see here. Do I have financial declarations for both?
Your Honor, I am also unemployed at this time. But I don't think financial declarations were made, no.
And I've just gotten into this. I'm reviewing the pleadings quickly. It looks like the parties have not filed a financial declaration. I can let the court know that my client has been without work for a while and has just started working with DoorDash.
All right. I think at this point, probably appointment at county expense makes sense for both. I don't know, who's our next three guardians?
Keith Lawrence,
Okay.
Michael Corey, Amy Turnbull.
All right. So Mr. Lawrence, Ms. Corey, and Ms. Turnbull.
I will not strike any names. Any of those are fine with me.
Okay. And Ms. Boaglio, did you have any, we would go down the line, there would be Mr. Lawrence, then Ms. Curry, then Ms. Turnbull. Do you have any objection to any of those?
I'm really not familiar with any of them, so I don't have an objection, no.
Okay, so that would be Mr. Lawrence would be first in line, so we'll go ahead and appoint Mr. Lawrence at county expense. And let me see here. So Ms. Powers, if you want to prepare that order, your client did make that motion, so that probably is appropriate.
Yeah, will the court give us does the court want an interim review on this one?
Probably not necessary.
Okay.
Just our 30-day or our initial review to make sure everybody's been in touch, and then a final.
Okay, and how far out would you like me to put the final?
Maybe 60 days. I don't think this is a real complex case.
No, I don't think it is. So if we went out and had it due July 26th and review it on the docket July 30th?
That should work.
Okay.
So, I'm sorry. So does that mean that we would have a guardian ad litem appointed on July 26th, or that their
No,
review would be made by then?
I'm appointing Mr. Lawrence today.
Okay, thank you.
And so you'll both need to be in touch with him, and then he will have a report for us by that time.
Thank you. And I didn't receive any notice of Amy Powers representing. Will I receive something like that, or has something new been filed with the court?
It should have gone out into the mail to you, my notice of substitution. I will touch base with my legal assistant and make sure it's gone out to you. If you're comfortable receiving things by email, we can also email it to you as well.
Email might, let me think about that. Email might be better just because I get things a little sooner.
Okay.
And it looks like that was filed with the court May 24th. So probably over the weekend, it has not made it to you.
Memorial weekend, yes. I have not received it yet.
So on the motion for contempt having to do with support, Ms. Boaglio, any comments you'd like to make on that? I did review your motion.
On the motion for contempt?
Correct. It's on the child support issue.
I feel as though I read Jonathan's response. I feel as though all of the matters pertaining to custody have a lot to do with the child support. So I feel like that everything that's included in that is important just to be considered. Yeah, I mean, his actions have led to me having to quit my job. So it's led to financial hardship for me, especially lately. But yeah, I don't know if I need to file another response with the court in response to his, or if what I've submitted already is enough.
Well, I just have the one that you filed in as a basis for the order to show cause. He then filed a response, which looks like that made it to, let me see here just a second. You did file a response May 1st. It really had, I think, focused mainly on, was a big part of that having to do with Mr. Zandy.
Okay, yeah.
So if you would,
sorry.
So if you want to file something additional, that's probably fine, because I have his response was filed May 8th, and if you want to reply to that, we can certainly set this over, like an opportunity to do that.
Yeah, I would appreciate being able to respond.
Okay. Any objection to that, Ms. Powers?
No, we're ready to proceed, but I have no objection to a set over.
Okay. How about if we go over 2 weeks on that to the 11th? So you'll need to get that to Ms. Powers probably by the first part of the week of next week at the latest. And then we'll come back on the 11th and we'll discuss the issue.
Would it be possible to go 1 week farther out? My client did file a motion to adjust child support, and I just wanted to docket it up. He filed the motion back in September, but never docketed a hearing. So my plan was to do that. And just for efficiency, if we could hear them both at the same time, that would be great.
That would be the 18th.
Yes.
Does that work for you, ma'am?
Your Honor, the documents that he filed previously were containing information that was not true about my financial situation and was including my husband's, which I believe he's not to include that to the best of my understanding. But yeah, I'd prefer if you would submit new documents with the court to reflect my current standing, my current financial situation.
Okay, well, here's what I'm going to suggest then is I can note all these matters on for the 18th. And Ms. Powers, if you can reference the specific documents when you file your notice, which documents we're dealing with as far as his filings. And then Ms. Blaglio, if you want to file a response to those documents specifically also, then I can look at that as well.
So file a response to his original one, is that what you're saying?
Correct. Unless you're going to be filing something additional, Ms. Powers.
My plan was to do some updated child support worksheets and probably a declaration from my client. To be safe, could we put it at June 25th? That would give Ms. Boaglio a little bit more time to review it and respond.
Does that work for you, ma'am? Oh, there is no docket that day. So we'd have to go to the 18th to the 2nd of July.
There's not a docket on the 25th?
There apparently is not.
Oh.
If we could do 18th of June, I am good with that. I believe we're going to be on vacation. My husband finally has some days off right around the 4th of July, and I'd prefer not to do it the first week of July.
Okay. So we could either the 18th or we could go to that second week, which would be the 9th of July.
I can do either one. I will do my best to get our stuff out today or tomorrow. I know technically it should be out today in order to be timely for the 18th. So that's my only concern about the 18th.
Okay.
Can I get an email address for you, please, Amy, so that I can send can I send proof of service through email? Is that, or sorry, not proof of, can I serve through email?
Yeah, that's fine. And I'll have my legal assistant draft up an agreement to send you. I am putting my email in the chat for you, my legal assistant's email. So we can be over to June 18th is fine with me.
All right. So put it on for June 18th at 1 o'clock and I'll review everything you file and we'll be ready to go at that point.
Thank you.
We get a hold of Ms. Williams. Okay. There we are. Good afternoon.
Good afternoon. Savannah Williams for Mr. Diaz.
Okay, so this was put on for a couple of things. It's a review. It's an interim JL report, but we'd set it over from a couple of weeks ago. Mr. Lawrence, I believe he is still there. I see him. He's requesting some action based on his report having to do with setting up reunification counseling. I don't really have a motion in front of me, so Mr. Diaz had made a comment. He has an attorney, so obviously you should be speaking for him. So that's where we're at.
Yes, Your Honor. On our behalf, I'm asking for a brief set over to continue getting fully caught up on this case, given the number of pleadings. I'd ask for just 1 week.
Okay. Let me see here just a second. Ms. Powers, do you have an objection to this going over a week for?
I guess my only comment is I'm not sure that anything needs to go over because it was just on for interim GAL. Mr. Lawrence has given an update, but there's no motion pending. So I'm just not quite sure what would set over.
Well, we had, I'm moving back here to the 23rd of April. Mr. Lawrence had made some temporary recommendation. There were some objections and we were switching attorneys out. And they don't have a motion pending on either side. So at this juncture, I mean, I could simply just strike the review. We have a report. Mr. Lawrence has made some requests in that report, and they let the parties make motions and we'll address it appropriately.
That's fine. I can dock it if we have anything.
Thanks, that works for me.
All right. So, Mr. Lawrence, I guess that I would reach out to the attorneys and you can chat with what you'd like to see them do, and somebody can file a motion and I'll address the motion when I see it.
I'll do that.
Okay. Very good.
Thank you.
You're welcome. I believe that's everything we have on this docket. So with that, we will adjourn.